Welcome back. In Module 4, we talked about who transfers. In Module 5, this module, I'm going to talk about what transfers. Regulation 4.2a of TUPE says that all the transfer rules, quote, rights, powers, duties and liabilities under or in connection with any such employment contracts pass to the transferee, the incoming employer. And in this module, we'll look at exactly what transfers. So we'll look at the basics. We'll look at accrued liabilities, such as pre-existing claims and the benefit of insurance policies. We'll look at union recognition agreements. Do they transfer? We'll look at pension rights, share schemes, restrictive covenants. Do they transfer? And we'll also look briefly at what doesn't transfer. So let's start with the basics. Now, it's not just what's written down on paper in the contracts that transfer. Although the written contracts of employment will contain some rights and liabilities, they won't necessarily cover everything. So the transferee, the incoming employer, has to do some research to make sure they know exactly what duties and liabilities they're taking on. This process is called due diligence. All statutory and contractual benefits will transfer. So that might include holiday pay, medical insurance or permanent health insurance, company car, contractual bonus and commission schemes, enhanced maternity and redundancy schemes. But TUPE won't create rights. TUPE won't create rights where they didn't exist previously. So a genuinely non-contractual policy, which wasn't legally enforceable against the transferor, won't transfer to the transferee because non-contractual policies don't contain rights or obligations. Non-contractual policies contained in a handbook will only transfer if they're incorporated into employment contracts, which is rare. What about accrued liabilities? Remember that the transferee steps into the transferor's shoes. Anything done by the transferor, the outgoing employer, the old employer, so anything done by the old employer before the transfer is treated as if it was done by the transferee, the new employer. So if an employee is injured before the transfer because of the transferor's negligence, liability for that injury will pass to the transferee, to the new employer. The same applies to acts and omissions which give rise to other types of claims such as unfair dismissal and discrimination. So it's vital for transferees, incoming employers, to ensure that they're suitably indemnified by the transferor against pre-transfer liabilities, ideally backed up with an insurance policy. And an indemnity means that the transferor has to compensate the transferee if any of those liabilities result in a claim against the transferee, the incoming employer. Discrimination. Equal pay claims for any pre-transfer period have to be brought within 6 months, which is the usual limitation period for equal pay claims, within 6 months of the transfer, even though the claim would be against the transferee. Because the limitation period in equal pay claims starts to run from the end of the employment in inverted commas. It's different from a standard discrimination claim where time starts to run from the date the discrimination took place or the end of any continuing act. So theoretically, a discrimination claim could be brought against a transferee, an old employer, for a pre-transfer thing, as long as it's brought within 3 months of the last alleged discriminatory act in a continuing series. That could be while they're employed by the transferee, incoming employer. What about insurance policies? An employee's right to benefit from an insurance scheme, such as private medical insurance, transfers to the transferee. A transferor's right of indemnity from an insurance company might also transfer. So let's say that an employer's liability insurance policy is triggered by a personal injury claim which predates the transfer. So the injury happened before the transfer. Liability for the injury transfers to the transferee. But does the right to be paid out under the insurance policy also transfer to the transferee? And this was tested by the courts in a case called Martin and Lancashire County Council. Here, the judge said the right to indemnity did transfer, and he pointed out that if it didn't transfer, an employer could potentially be left without a remedy. That's because a transferee is unlikely to have insurance relating to incidents predating the transfer. What about union recognition and collective agreements? Well, collective agreements aren't usually binding between the parties. They usually have a Tina Lee clause in them. Tina Lee. This is not a legally enforceable agreement. Another acronym. However, they can be relevant in some legal claims. For example, in deciding whether an employer has acted fairly, where the employers breached a collectively agreed redundancy procedure. So Regulation 5 of TUPE provides for any collective agreement made between a recognised trade union and a transferor to transfer to the transferee. Now, some parts of a collective agreement might actually be incorporated into employment contracts, and so they'll transfer that way. That might apply to a term in a collective agreement which stipulates how pay should be calculated, and that term can be enforced directly against the transferee. Contrast that with other parts of a collective agreement which won't be incorporated into contracts, for example, sections which deal with a collectively agreed redundancy process. Regulation 5 means that transferees, incoming employers, can't ignore such collectively agreed procedures. And Regulation 4A of TUPE sets out that collective terms agreed or changed after the transfer won't automatically transfer where the transferee, the new employer, is not party to the collective bargaining process, the negotiations between an employer and a trade union. The collective terms which transfer are only those that apply at the point of the transfer. So if employees transfer from a local authority to a private contractor, any collectively agreed terms between the local authority and the trade union made before the transfer are binding, but any collectively agreed terms between the local authority and the trade union made after the transfer don't apply to the private contractor. Union recognition, just for completeness, union recognition also transfers to the transferee under Regulation 6 of TUPE, and it'll apply to both voluntary and statutory recognition. So that means that certain rights, such as the right for union representatives to have paid time off, transfer to the new employer. But this only applies if the organised grouping of resources, i.e. what transfers, maintains a distinct identity from the rest of the transferee's undertaking after the transfer. So that means the grouping's got to have the power to govern itself without the direct intervention of the new employer. If the transferee, the new employer, has operational as well as ultimate legal control, union recognition doesn't transfer. Don't ask me why, that's just the rule. If after the transfer, the transferring business is reorganised and fully integrated into the transferee's business, union recognition doesn't transfer. Now, Regulation 6.2b of TUPE allows for transferred recognition agreements to be varied or revoked. But if you're a transferee, you can't just revoke an agreement because of the risk of industrial action or an application for compulsory statutory recognition being made under the compulsory recognition legislation. Some things are better negotiated than litigated. Pension rights, do they transfer? Most rights under an occupational pension scheme do not transfer. Old age, invalidity and survivors' benefits under occupational pension schemes are expressly excluded from TUPE by Regulation 10. So the transferee, the new employer, does not have to mirror the transferor's pension provisions or contribute to their scheme. But this principle doesn't apply to early retirement benefits, including the right to retire early. So if a transferor's outgoing employer, if a transferor's pension scheme provides for early retirement with the employer's consent, then the employee's right to be considered for early retirement benefits transfers to the buyer. It's worth remembering that employees will become deferred members of the transfer rules scheme when they transfer. So it means that the transferee only assumes responsibility for the enhancements to an early retirement pension, not for the full amount. TUPE doesn't create the right to double recovery. What about share schemes and profit share schemes? Well, many profit share and share schemes say they're non-contractual, and non-contractual schemes don't transfer. Care should be taken, though, as non-contractual schemes can become an implied contractual term by regular use over a long period. And I talk about this at length in my course on changing terms and conditions. If a share save scheme is contractual, the transferee has to provide an equivalent scheme or potentially buy out the employee's rights if a similar scheme isn't available. Now, one of the questions I'm often asked about TUPE transfers is what happens to restrictive covenants. Now, although a restrictive covenant technically transfers along with the employment contract, it refers to the transferor, the old employer, rather than the transferee. So the employee who then leaves to set up in competition isn't allowed to compete with the old employer, but can compete freely with the new employer. The customers or activities they refer to will be those of the old employer, and this can cause problems. So transferees can seek to agree new covenants with key employees, and I'm going to look at changing terms and conditions a little bit later on in this course. Finally, what doesn't transfer? Well, the transferor, old employer, retains a few residual liabilities. If the employees have share options, the TUPE transfer might give employees the right to exercise those options under the transferor's share option scheme, and the transferor will have to deal with that. Accrued pension rights up to the transfer date also remain with the transferor. The transferor, old employer, also retains any criminal liabilities arising from issues such as breach of health and safety laws, breach of PAYE responsibilities, at least relating to the pre-transfer period. And that's because the obligations here and the money are owed to HMRC and not to employees. Thank you.